pattern 21, second is 85 or 2020.
First from the evidence also.
इनका जो है वो माइक
Evidence of the TW itself, it is proof that there was no unity of title, and it appears that the dispute is only with respect to the house on which the land on the house was constructed by original defendant was Lakshman, which is your lordship will kindly take the book to allow me to, for the purpose of showing that there was no unity of title and they have all separate positions over the land.
सर आप एक एक करके सब्सटैंशियल क्वेश्चन ऑफ लॉ पर ही एड्रेस करेंगे
जी वो तो शुरू में ही ऑलरेडी आउट से
बस दो सब्सटैंशियल क्वेश्चन ऑफ लॉ
जी वो ही है
आप दोनों सब्सटैंशियल क्वेश्चन ऑफ लॉ को वन बाय वन आप कौन सा जजमेंट क्या क्या एविडेंस क्या क्या प्लीडिंग क्या क्या फाइंडिंग रेफर करना चाहते हैं एक के बाद एक करें पहले फर्स्ट सब्सटैंशियल क्वेश्चन
should have been learned first committed diversity by must be specific the agreement not to be a family agreement between the parties. So this what my submission is that the agreement E is a family agreement, family settlement.
Exhibit A is a family settlement.
And it was not required to be registered one as having head of the
And does not require registration.
registration. Exactly.
So I will just record that as per you, Exhibit A is a family settlement and it does not require registration. What else?
The second is not the first appointed committee.
No, ये ऐसा नहीं है. इतना ही सबमिशन है क्या सब्सटैंशियल क्वेश्चन ऑफ लॉ 1 में?
For that, the decisions which I have cited.
नहीं सर, वो नहीं क्लियर है. आप हमको बताइए कौन सा डिसीजन आप इसमें साइड करना चाहते हैं इस पॉइंट पर? एग्जिबिट ए पर.
एग्जिबिट ए पर दिया हुआ 1994 वॉल्यूम 4 एससीसी
1994 वॉल्यूम 4 एससीसी
पैराग्राफ 14 and 15.
पैरा 14 and 15 जरा प्लेस करिए सर. Let us see what was the matter about. In 1994 volume 4 SCC 294
Yes.
para 14 and
15 and 16. Sorry, not 14.
para 15 and 16. 15 and 16. पढ़िए para 15 and 16.
Equally incorrect is the assumption made by the High Court that the Court of First Appeal had not accepted the case of petition on the foundation, but the Appellate Court has found is as follows. With regard to partition, alleged by the defendants, even though the plaintiff has own witness, even one has admitted that there was a partition amongst the plaintiffs, Nirma himself, and first defendant accused. There is no satisfactory evidence to prove that in that partition the suit
Just a moment. In this particular case before the Supreme Court, there were earlier two suits, and in that case it was asserted that there was partition. Para 16 पढ़ी.
Therefore, what has been held is that property had not been allotted in the in the partition. That is very different from holding that the case of partition had not been accepted by the case partition. This being so, a decree for partition could not have been filed on a mere application for amendment. In fact, as rightly held by the Government Council of India, that causes of action are different in every part also. Before the degree of definition of the national rather radically smaller unit of partition could be granted with incorrect. Remember, a suit for partition, partial partition, then otherwise a suit for partial partition in the absence of inclusion of other joint family properties and infringement of other procedures are not warranted in law. Thus, we find no difficulty in regarding these appeals, which are at the
So here, question of law is not relating to partial partition. It is confined to Exhibit A. You have to see Exhibit A whether it is a document of partition or not. And therefore, the later observation that partial partition is not there.
By the coordinate bench of this honorable court also.
No, we are not. Partial partition is not the subject matter of point of substantial question. Therefore, we are not going into the plea of partial partition.
Because the suit, in fact, has traveled to the extent of only a house which was constructed by Lakshman.
That was not the suit. The suit was for partition of the property. We are not concerned. You just, sir, please. In second appeal, you have to confine yourself to the substantial. Exhibit A का पूरा उसके बारे में आपको जो बोलना है.
मेरा कहना है कि
1994 के जजमेंट का बहुत ज्यादा कुछ रेलेवेंस लग नहीं है. दूसरा जजमेंट कौन सा है?
पार्शियल.
दूसरा जजमेंट.
वो तो डायरेक्ट जो है 2000
बताइए दूसरा जजमेंट.
ये जो 2000 जो जेबीसीजे का जजमेंट है 2020 वॉल्यूम 3 जेबीसीजे है
2020 वॉल्यूम 3
जेबीसीजे वो सादा डॉक्यूमेंट पर है वो फैमिली सेटलमेंट.
हाँ बताइए.
तो प्लास्टम में है जो हम पढ़े थे उसमें.
नहीं प्लास्टम से नहीं पढ़िए आप जजमेंट से पढ़िए.
जी जजमेंट से पढ़ो जी इसको पढ़ो तो बार-बार. हाँ मैं यहाँ पर तो इसको 14 15 16 19 21 पढ़ो तो यहाँ से निकाल के 14 से पढ़ो. Yes. My friend would be reading those. Follow for this time.
कौन सा पढ़ रहे हैं?
Paragraph 14.
Stated portion of the judgment of the High Court.
पढ़ी.
Judgment of the High Court is in paragraph 12 or above. It is implied by clear that the High Court has not dealt with the actual aspect adverted by the first appellate court to conclude that the document is 6 was only a memorandum of family settlement are not a document containing the terms of and the decision of a family settlement being the former no registration was necessary for which a reason relief claim by the plaintiff founded on the family settlement between the real brothers arrived at 1970 upon without the exception and documented on thus in 1988 or para 15. The first appellate court
इससे आप क्या बोलना चाह रहे हैं? The High Court had recorded a finding that it was a memorandum of family settlement and therefore it did not require registration. Right?
ये ठीक है. बस यही कहना है जो फैमिली यही अल्टीमेटली कंक्लूजन है और कोर्ट ने इसको यही इंडोर्स किया है कि इस तरह को इनकरेज करना चाहिए सो एज टू avoid the greater dispute among the families, as it is not.
So to
In the
say that
welfare of the
memorandum of family settlement does not require registration. This is the only point you want to refer to?
As regards the first two substantial. Therefore, Lords, the finding recorded by the lower appellate
No,
court.
just a moment. इसमें अल्टीमेटली सुप्रीम कोर्ट का क्या फाइंडिंग है इसमें? आप इसमें इंटरनल पेज 466 में आइए. 466.
जी. Family arrangement may be oral on which no registration is necessary. This
No,
one.
no, no. In paragraph 10 of the said decision, the court has delineated the contours of essentials of a family settlement.
Yes, sir.
But
So decision the court has delineated the contours of the essentials of a family arrangement as follows. In other words, to put the binding effect and the essentials of a family settlement is considered of the matter may be reduced into one of the following conditions. The family settlement must be a non-family one so as to resolve family disputes and rival claims by fair and equitable division.
so fair and equitable settlement is equally important,
Yes.
right? Unless the family arrangement is bona fide, fair and equitable, it cannot be sustained by itself. It has to be fair and equitable.
It has to certainly it should be fair and equitable. The said settlement must be voluntary and should not be reduced by coercion. Therefore, not from exhibit 1, it is clear that there was the punches were there, they have put their LTI
No,
signatures.
that's it. Mere punches were there is not sufficient. It has to be
the
fair and
parties,
equitable.
parties to that order had also put their
Right, everybody might have agreed, but the point is whether it was fair and equitable.
Certainly. That is there is no finding of the lower appellate court that it was not a fair and
We'll see
equitable.
that.
It has simply said, since it was on plain paper and not registered, therefore it had doubted the credibility of that particular exhibit.
That's right. Okay, we have seen this. This judgment. Okay. So on the first substantial question of law, you are relying upon these two judgments. What about the second substantial question?
Second is not, there is no, it can be said to be a perverse one because of the fact there is no finding that it was not any fraud was played as has been alleged by the blood plaintiff.
So second, if point 1 is answered in your favor, second is automatically.
Automatically, exactly.
If the point A is against you, then
Dependent
second
upon the
is
second is
both
dependent
are
on the
correlated with each other.
Interdependent.
Respondent बताइए.
The parties are Hindu, governed by Mitaksara School of Law.
Okay.
So there is a presumption of jointness, unity of the titulars, unless until it is proved that the partition has already been done previously. Which according to me, the plaintiff, no partition, it was a convenience, but no partition by meet and bound was happened. That's why I filed the partition suit. So the defendant has disputed that they say that there is a partition already, So the onus lies upon the dependent to prove that there is an earlier partition. The only document which the dependent has produced is an exhibit A. Exhibit A doesn't say about the actual partition. Furthermore, when the cause of action arises by exhibit 4, I would like to exhibit 4.
What is exhibit 4?
4? The cause of action when arises before the circle officer when my ingress and egress was stopped by the defendant, then I file a proceeding was initiated.
We are not on cause of action. We are
नहीं,
just on exhibit A.
नहीं इसलिए कि उसमें कहा गया कि दोनों पक्ष एवं विपक्ष के पास बंटवारा का कोई कागजात नहीं है till the date
वो वहाँ पे क्या प्रोड्यूस हुआ
हाँ,
उससे हम लोग गाइडेड नहीं हो सकते
हैं, लेकिन ये चीज मेरा कहना ये है कि 2003 तक the exhibit A was not seen the light of the day.
आप ऐसा फोर्ज एंड फैब्रिकेटेड पे तो है नहीं, ना ही कोई
Forged and
ऐसा
fabricated हम अपने लिए-
कोई ऐसा सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना।
हाँ,
आप सीधा एग्जिबिट ए पर आइए और हमको बताइए कि उसका रजिस्ट्रेशन जरूरी था कि नहीं है, उसका पार्टीशन एक्चुअल में हुआ था कि नहीं था, या उसका क्या रिक्वायरमेंट है, आप बस इतना बताना है आपको।
हाँ, बस।
उसके बियॉन्ड थोड़ी
हाँ,
बता।
उतना ही हम बता देते हैं। तो एग्जिबिट ए जहाँ तक का सवाल है, the appellate court has not said that it is not a registered document, that's why it will not be taken into consideration.
Let us see the finding of that.
Yes, 27 पे पारा 27.
नहीं ऐसा कहिए इसको, पैरा नंबर 26 से पढ़िए।
27 is the
26 से पढ़िए।
because the trial court has not discussed about exhibit A. Simply they presume that there is a earlier part. RS 26 से पढ़िए। The plaintiff, dependent appellant, in order to show previous partition, put reliance on the Panchanama exhibit A.
Yes.
From perusal of the said document, it appears that same has been written on a plain paper. That's only thing what the appellate court has said.
Yes.
On which some signature and thumb impression are available.
No dispute on this.
On notice on
आगे पढ़िए। number।
as per the said document on 24/5/1978, a panchayati was convened in the house of the Muneshwari Devi for the partition of the ancestral property of the ancestor, not confined to the between the both the sons of Muneshwari Devi, namely Vibhuti Mandal and Lakshman Mandal. In the said panchayati, both the brothers were given half portion each in Mauja Kakaniya in Jamabandi number 30. Vibhuti Mandal was given the house standing over plot number 474, area 4 decimal, and out of 4 decimal of land in plot number 475, 1 decimal in back side was given to him, and remaining 2-3 decimals on road side is given to the Lakshman Mandal. As Lakshman Mandal is constructing his house, Mother Nuneshwari was given 8 kattha land for her maintenance, and after his death, this said land will be also be partition between the both the parties.
No dispute on this.
No dispute. I am not disputing about this.
No
27 पर हम जा रहे हैं. What is the discussion at your project?
Yes.
The recital of the document in question goes to show that the document is not a document of partition. So previous partition का यहीं से शुरू होता है. It only made a amicable arrangement, which my learned friend also accepts that it is only a amicable arrangement between the parties for the convenience. This has been admitted by my learned friend also. The document does not contain the plot number and the area of the land which has been allotted to both the parties.
प्लीज होल्ड ऑन, ये जो यहाँ दिया हुआ है जेबी नंबर, प्लॉट नंबर जो और 475 दिया हुआ है,
हाँ, उसका में से किस एरिया में किस पोर्शन पर होगा पार्टीशन, इनको मिलेगा, किस एरिया में किस साइड में उस बाउंड्री पर इसको मिलेगा, ये तो नहीं दिया हुआ
बाउंड्री
है।
एंड दोनों का पार्टीशन और एरिया नहीं दिया हुआ।
नहीं दिया हुआ है,
आगे बताइए।
नहीं दिया हुआ था उस डॉक्यूमेंट में ही। both the parties and
देर मदर,
their mother, though the document says that after the death of the mother both the brother could make partition of the land possessed by her, but how much land and in which portion of the land, actually meets and bounds का मतलब है ये होता है।
कौन सा पोर्शन है,
कौन
फ्रंट
सा
है,
portion?
बैक है?
हाँ, in which portion of the portion the brother will get has not been mentioned. In such position, it is clear that the document is not document of memorandum of partition. It seems that the learned lower court has wrongly misinterpreting the document as document of partition and passed into judgment. Because the learned trial court has also said that there is a previous partition. There is no previous partition except this document.
This is the only document.
And this document doesn't say about the partition because it is cannot be said to be a document of partition. So the suit ought to have been allowed for partition between the two brothers.
So it has been held that it is a document of convenience.
Convenience.
And then it has been held that it is not a memorandum of partition.
No, not a memorandum
Because
of partition.
Exhibit A by itself is dividing the properties, whatever in whatever manner, maybe for convenience.
Right? Like for the convenience, but there is no partition by meets and
So
bounds.
there are two kinds of documents. There are three kinds of documents, plain documents. One is arrangement for convenience. Another is a memorandum of previous partition. That
Yes.
previous partition has already been done and we are just putting it on record
उसमें
for the
registration
memory.
उसमें registration
उसमें
की
registration का
जरूरत
जरूरत
नहीं पड़ता है।
But-
अगर previous partition हो
But
तो
if it is a document of partition,
Of
it
partition.
requires
it requires registration.
Exhibit A on the face of it is reflecting that some kind of arrangement with respect to
Arrangement.
some property is being made.
So it
And
can,
even if this document is taken as a document of partition, then under such circumstances it would require registration.
yes, that's why I am trying to convey your lordship, because if it would be it is deemed to be a previous partition, then it requires, because if it is will be treated as a partition, document of partition, then it requires registration. Or if there is a prior partition to that document, then there is no
If A is a family arrangement,
arrangement,
then it would require partition,
partition,
registration.
registration.
It is not a memorandum.
It is not a memorandum of partition. And similar substantial question was involved in one of the second appeal, your lordship, and that was decided in favor of the. It was answered. That is 2002 AIR Jharkhand, page 1108. 2002 Jharkhand, 1108. Para 8 was the substantial question. At 1108. At the time of admission, the appeal following substantial question of law was framed, whether in view of the statement made in paragraph so and so in the written statement, the learned court below could have refused to take into consideration and marked as an exhibit the memorandum of partition marked Y for identification and refused to take the same into consideration as a memo of partition does not require registration in terms of proviso of section 42. Answer is para 9. Appellant counsel submitted that the said document dated 22/3/1976 being a memorandum of partition, even if unregistered, was admissible in evidence. That's why I am saying a perusal of the said document and especially the endorsement made thereon by Sarpanch, and in absence of any recital that partition was already effected earlier, it cannot be termed as a memorandum of partition. Rather, by this document, in presence of Mukhia and Sarpanch, actually partition was effected on such and such day itself, and thereby 38 acres land, the detail therein was allotted to Musma so and so, plenty number is surprisingly nothing is mentioned in therein with respect to the allotment of land in any to Barai Ram Singh, husband of the defendant number 1, for the reason also this said document could not have been accepted as a document of partition by metes and bounds between the parties. It was not admissible in evidence, therefore said substantial question has been decided accordingly. So this document will not be even admitted in evidence in view of the fact that there is nothing on record to suggest that there is earlier partition by metes and bounds, and only for the purpose of convenience they have made a family arrangement and written down in plain paper. So that cannot be a basis to come to a conclusion by the learned trial court that there was a previous partition. So previous partition has not been done, and this document cannot be shown to be the document of previous partition. And in that view of the matter, the learned appellate court has rightly held that there is no partition by metes and bounds, so the parties are entitled for partition also.
आपको कुछ बोलना है रिस्पॉन्स में?
इसको थोड़ा सा जो एविडेंस आया है PW1 का, 2 का, 3 का, वो यही प्रूफ करता है कि there was previous partition among the parties. There was no unity of title on the day the suit was filed. They were living separately, completely. थोड़ा सा हम इनका समय लेंगे. पैराग्राफ 5 पढ़ रहा है ऑर्डर 18 में जो डिक्लेरेशन ये लिखे हैं स्टेटमेंट उनको यह कि इसके अतिरिक्त जज सर्वे डाक नंबर 700 PW1 में जिसमें बातों का
सर एग्जिबिट ए के अलावा तो हम क्या ही देखेंगे? In considering the substantial question of law, I have only to see exhibit A. There is no such substantial question of law. Sir, is it your case कि exhibit A के पहले partition हो गया था? That is not your case.
Previous partition already था. इसके लिए
By virtue of exhibit A.
Not only by virtue of only exhibit A. मैंने वो जो उसके पहले जो है उसमें आया है और ये जो झगड़ा है केवल एक घर के लिए ये प्रूव हुआ है. उसी में थोड़ा सा पोर्शन हुजूर को दिखाना चाहते हैं.
कौन सा डेट को प्रीवियस पार्टीशन हुआ? डेट बताइए.
डेट नहीं है.
फिर क्या?
They are all villagers.
नहीं, villagers कोई एक्सक्यूज थोड़ी है.
फिर भी नहीं उन्हीं का भी पोजीशन.
The court makes no distinction.
उनके स्टेटमेंट से PW's के स्टेटमेंट से हमारा नहीं. हम PW's पर जा रहे हैं कहा कि they have to prove their case. तो उन्होंने कहीं नहीं कहा है जैसे यही दिखला रहे हैं थोड़ा सा just. I'm really obliged to your lordship giving me that this much of time to pronounce our nonsense. इसमें बातों का झुंड है. गत वर्ष दाग नंबर गत सर्वे में दाग नंबर 700 मोगा ककनिया मोगा खतियानी रहितों के नाम इजमाल दर्ज है जिसका भोग दखल सभी फरीखान सुल्तानुसार करते आ रहे हैं. प्रीवियस जो है वो लोग अपना दखल अब वो चीज जो है
कौन अपना दखल करते हैं?
उसके लिए सूट नहीं फाइल किया ना.
कोई बात
उसके लिए तो सूट नहीं फाइल किया ना. इसलिए ये पार्शियल पार्टीशन है. जैसे एक
अरे पार्शियल पार्टीशन में कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है, इसलिए आप बार-बार पार्शियल पार्टीशन में क्यों जा रहे हैं?
अब देखिए हम जो कह रहे हैं इसमें कि इसमें जो है जो प्लेंटिफ है उसको केवल ग्रज है एक मकान के लिए. इसलिए हम पार्शियल पार्टीशन पर जा रहे हूँ।
नहीं तो that is not the question of law.
जस्ट उसी का डिपोजिशन में पैराग्राफ नंबर 18।
सर जो चीज क्वेश्चन ऑफ लॉ नहीं है उस पर आप क्यों बहस कर रहे हैं?
इसलिए
That is not the question of law before us.
इसलिए कि जो के सामने सवाल आ रहा है,
नहीं आ रहा है सवाल, आप सवाल रेस कर रहे हैं, ऐसा आ नहीं रहा है कोई सवाल।
प्रीवियस पार्टीशन की बात आ
Exhibit
रही है।
A, only the interpretation of Exhibit A is before the court by virtue of the substantial question
ठीक
of
है,
law.
तो मेरा कहना है
उसके
कि
beyond आपको कुछ देखने
उसके
की
लिए
जरूरत ही नहीं है।
वो जो है बिल्कुल बाइंडिंग है upon the parties, not even if it is not it was simply a family settlement, it was a family arrangement, not a memorandum of partition. It was not a memorandum of partition. Memorandum of partition नहीं है, वो फैमिली सेटलमेंट है जो कि सुप्रीम कोर्ट।
फैमिली सेटलमेंट किसको बोलते हैं?
फैमिली सेटलमेंट
अगर मान लीजिए आप
फैमिली को स्थापित करना,
पारिवारिक व्यवस्था को स्थापित करना,
जी,
एंड इट इज नॉट अ पार्टीशन,
इट्स
तो इसका मतलब क्या हुआ? इसका मतलब देयर इज नो प्रीवियस
फैमिली
पार्टीशन,
सेटलमेंट हुआ।
देयर इज नो प्रीवियस पार्टीशन।
प्रीवियस पार्टी फैमिली सेटलमेंट को माना गया, दैट वाज एक्टेड अपॉन, इवन दिस एग्जीबिट ए वाज एक्टेड अपॉन, क्या कि एग्जीबिट ए के आधार पर हम अपना घर बनाए, लक्ष्मण मंडल ने अपना घर बनाया, जिसके बनने के बाद से ये प्रॉब्लम हुआ।
ठीक, जजमेंट सुनिए। ऐसे नंबर 85 of 2020 heard the learned counsels appearing on behalf of the parties. This appeal was admitted by the order dated 28/3/2023 on the following substantial questions of law. The learned counsel for the appellant, by referring to the substantial questions of law, has submitted that the substantial question of law number 2 would be directly dependent on the answer to substantial question of law number 1. He submits that if the first substantial question of law is answered in favor of the appellant, then automatically the second substantial question of law would follow. With respect to the first substantial question of law, the learned counsel has referred to Exhibit A and had submitted that it was a family arrangement between the parties to the suit and their ancestors. He has also submitted that Exhibit A was not an amicable arrangement between the parties for their convenience. Rather, it was a Panchnama dated 28/5/1978, wherein partition was effected. Okay? He submits that Exhibit A revealed that there was a partition,
फैमिली सेटलमेंट हो,
there was a family, it revealed that there was a family settlement, and therefore there was no occasion to hold that the property was still joint and could be subject matter of partition. The Learned Counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 1994 bracket close 4 SCC 294 paragraph 15 and 16 to submit that there cannot be partial partition, and he has submitted that there were other properties which were not included in the suit. The Learned Counsel has also relied upon the judgment passed by Honorable Supreme Court reported in 2020 within bracket 3 JBCJ 455 within bracket SC, and has in particular referred to paragraph 14 thereof. To submit that the family settlement made amongst the family members has been given much weightage as the same seeks to sink their differences and disputes and settle and resolve their conflicting claims or disputed titles once and for all times to come, and by peace and harmony amongst themselves. And such arrangement ought to be governed by special equity peculiar to them and would be enforced if honestly made. The Learned Counsel has submitted that the Exhibit A was a family arrangement and therefore the substantial question of law is fit, law number 1 is fit to be answered in favor of the appellant and against the respondents. He has submitted that so far as second substantial question of law is concerned, if Exhibit A is held to be a family arrangement, there would not be the natural corollary would be that there was a previous partition and therefore there could not be any fresh partition, as after the previous partition there was no unity of title and possession with respect to the suit property. यही है, ठीक है? Between the parties. The Learned Counsel, appearing on behalf of the respondents on the other hand, has opposed the prayer and has submitted that the specific case of the defendants before the court was there was a previous partition by virtue of Exhibit A. He has submitted that Exhibit A cannot be termed as a document of partition as cannot be termed to be a document of partition and hence cannot be termed to be a document of family arrangement. Inasmuch as the Exhibit A did not mention as to which portion of the property will go to one or the other brother. And it also did not mention as to which portion of 8 kattha of land will be given to the mother as maintenance. The learned counsel submits that it was at best a document of convenience and there has been no partition by meets and bound, and therefore the suit for partition was maintainable. He has further submitted that even if Exhibit A is taken as a family settlement, even if assuming Exhibit A to be a family settlement, then also by no stretch of imagination it can be said to be a memorandum of partition, and consequently it would require registration. And in absence of registration, the Exhibit A would have no value. He has relied upon the judgment passed by this court, reported in 2002 AIR JHAR HCR 1108 and has referred to the substantial question of law framed therein and has submitted that an argument was advanced in the said case that the document in question was a memorandum of partition and therefore even if unregistered was admissible in evidence. However, the court recorded that the said document did not mention any recital of previous partition and therefore it was held that it could not be termed as a memorandum of partition. And therefore it was held to be not admissible in evidence due to want of registration. The learned counsel submits that Exhibit A at best could be a document of convenience with respect to possession of property, and therefore in absence of any previous partition by virtue of Exhibit A, the suit for partition was maintainable and the substantial questions of law are fit to be answered against the appellant and in favor of the respondents. That is all. After hearing the learned counsel for the parties, this court finds that a suit for partition was filed by Gauri Devi, daughter of late Vibhuti Mandal, seeking claiming half share by meets and bound of the suit property described in Schedule A and B of the plaint. It was her case that the land pertaining to JV number 30 of Moza Kakania was exclusively recorded in the name of Ludhu Mandal, which was described in Schedule A. And plot number 124, measuring an area of 45 decimal in Moza Kakania, was occupied and got settlement by said Ludhu Mandal. And similarly, plot number 134, measuring 21 decimal, was occupied by the father of the plaintiff, and the defendant number 1 got settlement by village pradhan, and it was described in Schedule B of the plaint. Schedule A and B property of the plaint were to be the joint property of plaintiff and defendant, and they were termed as suit property. It was her case that Ludhu Mandal died leaving behind his two sons, Vibhuti Mandal and Lakshman Mandal, who jointly inherited the suit property, exclusively recorded in the name of Ludhu Mandal, and both the brothers remained in joint possession of the suit property. Vibhuti Mandal died in the year 1999, leaving behind his daughter Gauri Devi, the plaintiff, who is the heir and successor of Vibhuti Mandal. Lakshman Mandal was the defendant number 1, and defendant number 2 and 3 were his sons. It was also her case that certain other properties were ancestral joint properties, and the same was left out from the suit property, as that would include a large number of co-sharers, and the plaintiff reserved their right to file partition if any. A written statement was filed by the defendants, and in the written statement, as is apparent from the statement, written statement. As is apparent from the records received from the court concerned, a specific plea was taken by the defendants at paragraph 12 that there was a previous partition in the year 1978 by the mother of Vibhuti Mandal and Lakshman Mandal with the help of punches and a memorandum and a memo of Panchnama was also prepared, in which the land of Rudna Mandal was partitioned half and half, allotting half to Vibhuti Mandal and other half to Lakshman Mandal, and 8 kathas allotted to Nuneshwari Devi, the mother of Vibhuti Mandal and Lakshman Mandal. (12 and 13). In support of and consequently a plea of previous partition was raised. The learned trial court issues as framed as many as 8 issues, and considering the substantial question of law involved in this case, नहीं, 8 issues quote करते हैं issues को. The Panchnama dated 28/5/1978 was produced by the defendant and was marked as Exhibit A, which is the bone of contention between the parties, as is apparent from the substantial question of law as framed. The issue number 4, 5, and 7 were taken up together, and on behalf of the plaintiff, it was contended before the learned trial court that the said document that is Panchnama Exhibit A was not admissible on numerous grounds. A, it was not registered. It was neither registered nor stamped. B, it does not appear to be a Yadasnama, that is memorandum of partition. Memorandum. It does not, number 3, C, it does not state as to which land were allotted to defendants and which land were allotted to his brother, father of the plaintiff. उसके बाद next D. The document Exhibit A was neither admissible nor it indicated partition on meets and bounds. It was also urged that under Nitakshara School of Law, there is presumption of jointness and there was no proof that partition had taken place on 24/5/1978. It was argued by the defendant that Yudha Mandal died leaving behind 2 sons and his wife, who also died in 1985. And Vibhuti Mandal and Lakshman Mandal, with the help of their mother, Panchas, partitioned and separated their land, and a paper was written, witnessed by Panchas. Land of Yudha Mandal partitioned half and half to Vibhuti Das and Lakshman Mandal, and 8 katha was allotted to their mother in the year 1978. And thereafter they came in exclusive possession of their respective shares. It was asserted that the partition was done on mutual consent and agreement and not for convenience. And therefore there was no cause of action to file the suit for seeking partition. The learned trial court after considering the materials on record held in paragraph 27 held in paragraph 27 and 30 that there was a partition made between both the parties in the year 1978, and specific share was allotted by family arrangement in the year 1978. The finding in paragraph 25, 27 and 30. 27 to 30 is quoted as under. So far as the learned first appellate court is concerned, the finding in connection with Exhibit 5 has been recorded in paragraph 26, in paragraph 27 and 28, and the specific case of the defendant, paragraph 26 to 28, which is quoted as under. The specific case of the defendant to show previous partition was reference to Panchnama dated 28/5/1978, which was exhibited as Exhibit A, and the learned first appellate court recorded specific features of the said document. In paragraph 26 of the impugned judgment, and in paragraph 27 recorded that the said document cannot be said to be a document of partition, as it made only amicable arrangement between the parties for their convenience, and the reason for recording such finding was that it was not clear as to which portion was allocated to one or the other brother and their mother. It was also held that the said document cannot be said to be a document of memorandum of partition. Upon perusal of Exhibit A, this court finds that it is dated 28/4/1978, and it records that, and the same does not record any previous partition. Rather, it refers to the partition done on the same day, that is 24/4/1978. Although it talks about allocation to the Nuneshwari Devi, the mother, and her two sons, but it does not earmark the portion allocated to each one of them. this court finds that the first appellate court has rightly recorded that the said document is not a document of memorandum of partition. This court also finds that the said document cannot be said to be a document of partition by means and bound. Even if it is assumed for a moment that the said document, which certainly does not refer to any previous partition, is a document of partition, then also the same would be inadmissible in evidence being unregistered. This aspect of the matter is squarely covered by the judgment relied upon by the respondents in the case reported in 2002 AIR in Jharkhand HCR 1108. In the judgment passed by Honorable Supreme Court in the case of Ravindra Kaur Grewal, it has been clearly held by referring to the earlier judgments that in a case of family arrangement, the property is required to be equitably divided between various contenders so as to achieve an equal distribution of wealth. And it has also referred to the essential contours of a family settlement, which is to be in a concretized form, and matter may be reduced in the form and such a settlement should be bona fide and to resolve family dispute and rival claims by a fair and equitable division or allotment of properties between various members. The judgment also made a distinction between a document containing the terms and recital of a family arrangement made under the document and mere memorandum prepared after the family arrangement has already been made, either for the purpose of the record or for information of the court for making necessary mutation. And it has been held that even if the parties to the settlement has no title, but under the arrangement the other party relinquishes all its claim or title in favor of one or the other person, then also it can be upheld. However, the document by itself partitioning the property would require registration. This court is of the considered view that in view of the aforesaid findings in regard to Exhibit A, the same cannot be said to be a family arrangement. Having any binding force between the parties. And no reliance can be placed on Exhibit A to hold that there was a previous partition between the parties to the suit and their ancestors. In view of the aforesaid findings, both the substantial questions of law are decided against the appellant and in favor of the respondents. This appeal is accordingly dismissed.
IA filed किए थे.
क्या चीज़ में?
One IA was filed by the appellant
For what?
for stay of the proceeding for final preparation of the final
IA
DT.
closed.
IA may be disposed of.
IA close, सब IA
Close.
ऑटोमेटिक क्लोज हो जाता है.
नहीं उसको क्लोज तो करना है.
सारे IA हम
ऑब्स्ट्रक्शन
लोग
हाँ
by
ऑब्स्ट्रक्शन कर रहा है
default
फाइनल
close
डिग्री
करते
में ऑब्स्ट्रक्शन कर रहा है हमारा पिटी कर रहा है.
हैं. वो आप जानिए और वो जानिए.
नहीं आपको डिस्पोजल किया तो
चलिए next case पर.
जो 2024 में जल्दी हुआ है उसको partition में
कौन सा 2024?
Independent government problem.
कौन सा?
2024 का जो ऐसे जो हो जाए
वो partial partition का. Partial partition का तो substantial question of law ही नहीं है तो क्या दे उसका क्या relevance है?
Item 22, second appeal 136 of 2022.
That this appeal has been admitted in terms of order number 5, dated 18/12/2023. There is a problem.
बताइए.
The question is whether the learned court below, appeal below, has failed to appreciate the sale deed number such and such dated 24/2/1960 as Bharnama and cancelled the same after long lapse of limitation as in message under section 59 of the limitation act.
भागनामा क्या चीज़ है?
Bharnama, there was Bharnama, there was a loan. In lieu thereof, the sale deed was executed.
Okay.
In this
Conditional
manner-
loan by conditional mortgage.
Not conditional mortgage. From perusal of deed, it will appear that it is a sale deed. But the
Outright sale.
yes, but it is nomenclature is Bharnama.
Nomenclature will not decide.
That is.
Let us see the sale.
But one thing
बताइए sale deed ही देखते हैं.
but one thing I would like to remark that I want to make some addition or alteration in this substantial question of law.
अब आपको क्या हो
देखते हैं बस उतना ही छोटा सा. No relief was sought for by the plaintiff regarding sale deed of 1960. No relief was sought for. मामूली करेक्शन है.
मामूली करेक्शन नहीं है. करेक्शन का मतलब है कि एडजस्टमेंट. अब
जब
मामूली
relief
करेक्शन
है-
में हम तो एक ही चीज जानते हैं, जहाँ करेक्शन करेंगे तो वहाँ आपको एडजस्टमेंट बोलिएगा
नहीं, हम नहीं
वही
मांगेंगे, हम नहीं मांगेंगे,
फिर क्या मांगेंगे?
अगला मांगेंगे,
ऐसा नहीं होगा ना, इस तरह से नहीं होता है ना।
अगला मांगेंगे,
सब्सटैंशियल
हमको नहीं
क्वेश्चन ऑफ लॉ
मांगेंगे।
बना हुआ है, ठीक है,
लॉ
और
बना हुआ है,
आपको कोई
लेकिन
लिबर्टी भी नहीं दिया हुआ है।
ठीक है, हम इसी पर बात
आप
करते
इसी पे
थे।
बहस करते हैं। बताइए क्या कहाँ है आपका डीड?
डीड है एग्जिबिट 2 बी है। एग्जिबिट बी है, ओरिजिनल बंगाली में है, उसका हिंदी वर्जन किया हुआ है। सिक्सटी वैसे तो और सब सब्सटेंशियल क्वेश्चन प्रपोज कर रहे थे हम, लेकिन जैसा आपका
इससे तो हो ही जाएगा, इसमें क्या करना है?
इससे तो हो जाएगा,
हाँ तो बस ठीक है।
लेकिन रिलीफ जो मांगा गया है which is apparently barred by limitation. Relief has been sought for with regard to a deed of 1987.
87 का तो कहानी नहीं कर रहे हैं, अभी आप इस डीड में जो है यहाँ एग्जिबिट नंबर कौन सा बताया? एग्जिबिट बी, इसका हिंदी में ट्रांसलेशन है, ये बंगला में है exhibit।
बंगला का हिंदी वर्जन दिया हुआ है, लेकिन टोन बंगाली है।
वो तो हम समझ जाएंगे।
हाँ, तो आप समझ।
तो हाँ पढ़िए जरा एग्जिबिट।
जी, जरा हेल्प ले लेते हैं ब्रेक का।
हाँ हाँ सर,
बड़ी जो है
बस पढ़ते जाइए, जगह अपने अगेंस्ट वाला जगह भी बताते जाइए।
सब शुरू से पढ़।
श्री नागेश चंद्र अग्रवाला, पिता गोपी विनोद अग्रवाला, जाति हिंदू, पेशा
ऊपर से पढ़िए ना, भरनामा केवाला, ऊपर से पढ़िए, भरनामा केवाला, मूल्य 7,000 टाका है ना ऊपर।
हाँ हाँ, बाएं तरफ में है।
नामा केवाला, मूल्य 6,000 टाका,
6,000 नहीं 7,000 हिंदी में,
7,000 टाका,
जिला सत्य, ठीक है। तो मेन यही है, भरनामा, दूसरा 7,000 टाका। आगे बताइए।
श्री नरेश नागेश चंद्र अग्रवाल, पिता सो पेशा सो, पता द्वारिका ठाकुर लेन कोलकाता। श्री शिव नारायण दास, श्री माधव नारायण दास, श्रीमती बानी दास, गंगा नारायण दास नाबालिग, श्री नारायण दास नाबालिग, श्रीमती अंबिका दास नाबालिग, सर्व पिता सत्यनारायण दास। सोळसो पक्षे अभिनाविका, माता व निज पक्षे स्वयं श्रीमती मधुमालती दास, स्वामी सत्यनारायण दास, जाति हिंदू, पेशा वर्सेस थाना स्वयं। कार्य को लिखित उपरोक्त दलील दातागण सभी दलील ग्रहीता श्री नागेश चंद्र अग्रवाल समादेर अथा उपरोक्त दलील दाता ने मृत्यु सत्यनारायण दास स्थान महामानव, कोलकाता हाईकोर्ट 1361 और 55। देवयानी नंबर उक्त सत्यनारायण दास से विरुद्ध 26,700 का डिक्री प्राप्त हुआ। उक्त डिक्री होव्यार पर हमारे उक्त सत्यनारायण दासेर मृत्यु हो गए। તો
હોય છે
હોયા છે તહાર મૃત્યુતે તહાર તખ્ત સંપત્તિ મોગી વારિસ સ્વરૂપે আমরা তাহার যে সম্পত্তি পাইয়াছি তাহা হইতে আমাদের ভরনা পোষণ চলাইয়া আপনার উক্ত ডিক্রিকৃত টাকা আপনাকে আদায় দিয়া পরিশোধ করা আমাদের পক্ষে असंभव ऊपर पक्षे अपनी उक्ति डिग्री
बोला कि इतना पैसा हम नहीं दे सकते हैं. दिस इज व्हाट द कंटेंट इज.
ये
इसीलिए
भरण पोषण और पेमेंट के लिए ये सैलरी एक्सक्यूट किए
আমাদের বিরুদ্ধে জারি করিয়া উক্ত সত্যনারায়ণ দাসের তথ্য সম্পত্তি নিলাম করাইলে আমাদের ভরণ পোষণ চলার কোনো উপায় থাকিবে না এমতাবস্থায় আমরা আপনাকে অনুরোধ করায় अपनी दया
अपनी दया
पर्वत होया अपना उक्त डिग्री कृत टाका मोहे समस्त टाका हम दिगो के माफ दिया हमरा 7,000
वो
टाका
जो डिग्री था 26,000 नोट का उसको 7,000 पर अगला स्वीकार कर लिया।
सर्किल करिए.
टाका अपना के प्रदान करेले उक्त महामान्य हाईकोर्ट डिग्री संपूर्ण परिशोधित होइबे
For the satisfaction of the
That
entire
is
decree.
better. Only on 7,000.
प्रतिश्रुति देव्याय
Satisfaction of decree.
আমরা উক্ত টাকা আপনাকে নগদ প্রদান করিবার কোনো উপায় নদেখিয়া উক্ত 7,000 টাকা পরিবর্তে আমাদের मोरस उक्त सत्यनारायण दासेर तख्त संपत्ति मोहे निम्न तफसील विनित संपत्ति जहार वर्तमान सर्वोच्च बाजार मूल्य 7,000 टाका होय छे उक्त संपत्ति संबंधित अपनार बराबर के वाला संपादन व रजिस्ट्री कोरिया दिले अपनार उक्त तख्ता पाव्या सबोस्तो हाईवे एवं तंदूरा उक्त महामानो हाईकोर्ट उक्त डिग्री फुली सेटिस्फाइड हो गई उभय पक्षों मोये रूप स्थिर हो अमाहेर मध्य रूप स्थिर हुए पर আমাদের अर्थात उपरोक्त दलील दाता ने मोये सो दलील दातागण नवालक था काय अपना अर्थात दलील रहितार निर्देश मत आमोदार मोये 7 नंबर दलील दाता श्रीमती मधुमालती दासी उक्त नवाल करने पक्षों अपना बराबर उक्त चुक्तिकृत वाला संपादन व रजिस्ट्री बराबर अनुमति बार जन्म
ये माइनर बच्चों के लिए वहाँ डिस्ट्रिक्ट जज के यहाँ जब गार्जियनशिप एक्ट का केस करके पावर लेगी
Power
टू
taken.
सेल
Judge ये वाला 1956. After taking due permission for this.
Yes, thereafter she sold.
તારીખો ઉક્ત અનુમતિ પ્રાપ્ત હોય છે એકોને ઉપરોક્ત મહામાનો કોલકાતા હાઈકોર્ટ 100 देवानी आदेश नंबर मुकदमा डिक्री उपरोक्त रुपये 7,000 टाका चुरांत मिमोसा होया या व्याय अर्थात 7,000 टाका बाय एडजस्टमेंट फुली सैटिस्फाइड होले रूप स्थिर हो गया है। उक्त 7,000 টাকা कंसिडरेशन जन्य उक्त 7,000 টাকা মূল্যের আমাদের মরস উক্ত সত্যনারায়ণ দাসের तक আমাদের स्वतंत्र दखली निम्न तफसील निर्मित संपत्ति उक्त 7,000 টাকা मूल्य संपूर्ण निर्धारित व निर्घोष अवस्थाएं अपना के उक्त केवाला द्वारा विकृत कोरिया शोरो अनामते निस्वत होल्डिंग एवं ताहार दखल अपना अनुकूले तैयार कोरी
I've seen it more or less for 7,000 rupees.
Pardon?
For 7,000 rupees.
For 7,000 rupees, 26,000 and odd का लेनदार मान गया 7,000 रुपया में वो सेल डीड कर दी, बजाते परमिशन लेके डिस्ट्रिक्ट जज
तो 7,000 रुपए उसको और मिला। इसका मतलब फॉर दिस प्रॉपर्टी शी गॉट 26,000 या जो भी प्लस 7,000।
ओनली
नो ओनली 7
भाई वो डिग्री सेटिस्फाई हो गया ना,
डिग्री सेटिस्फाइड हो गया।
प्रैक्टिकली क्या हुआ?
it has
प्रैक्टिकली 26,000 जो भी
Yes
डिग्री
sir,
था
satisfied.
एंड वो सेटिस्फाई हुआ प्लस शी गॉट 7,000 एडिशनल।
No. In 7,000, 26,700 की जगह पे केवल 7,000 रुपये मान गए। अगला लेनदार जो था 7,000।
अच्छा, वो 7,000 में मान गया कि हम 26,000 नहीं रियलाइज करेंगे, आप हमको 7,000 रुपए दे दीजिए, ये प्रॉपर्टी दे दीजिए।
चूंकि 7,000 ही नहीं दे सकती थी, इसीलिए ये प्रॉपर्टी अपना एक्सक्यूट कर दी बाई एक्यूटिंग सेल।
अच्छा, वो 7,000 रुपए में मान गया और उसके बाद जो है 7,000 रुपए में ये प्रॉपर्टी बेच दी क्योंकि 7,000 रुपए ये दे नहीं सकते। He did not have the money.
It will
And
clear
ये
from-
मेंटेनेंस का क्या कहानी है?
What is?
मेंटेनेंस का क्या कहानी है?
मेंटेनेंस का कहानी है, और वो मेंटेनेंस का कहानी उनका अपना है, उसके लिए परमिशन
अब वो
मेंटेनेंस
मेंटेनेंस करने की स्थिति में नहीं थी।
एडॉप्शन का केस था। ये माइनर थे उनके बच्चे, इसलिए उनके तरफ से गार्डियनशिप एक्ट का केस करके वो परमिशन ली थी डिस्ट्रिक्ट
To sell this property.
टू सेल। अब देयर आफ्टर दिस वन
That particular document has been exhibited.
yes
Permission has been exhibited.
yes just now I am giving the
वो
details
exhibit number कौन सा है?
yes नहीं, वो कलकत्ता वाला ऑर्डर सही है।
लेकिन it is mentioned in the deed.
शीट में तो मेंशन
According to you, it's a document of complete sale. ट्रायल कोर्ट appellate court क्या किया है इसमें?
ट्रायल कोर्ट डिक्रीड इन पार्ट,
Say what?
plaintiff preferred appeal,
Who
this
was the
suit was
plaintiff?
decreed full.
What was the suit for?
Suit for declaration, that was when I was firstly, suit for declaration of title and confirmation of possession along with the relief declaration that first party did not acquire any right, defendant first party did not acquire any right by deed executed by Hari Shankar and others, being deed number 6147 of 1987 at Calcutta, Exhibit B/1. And
That was a
confirming-
back-to-back sale deed. That was a back-to-back deed.
Yes. This Exhibit B/1 was executed by the person who was who had purchased the property from Madhumalti Devi in the year 1960.
Madhu Malti Devi in the year 1960.
On behalf
It was
of
a back-to-back sale deed.
In 1987 का deed is being challenged in the year 1993. And therefore, no prayer of cancellation of 1960 deed. That was cancelled by appellate court. And treating it as Varna now.
Their simple prayer was that no property, the defendant did not acquire any title by virtue of the sale deed dated 6/147/1987 because the back-to-back sale deed of the year 1960 did not confer any right, title and interest upon the vendor of 1987. If the vendor did not have the title, then they need not challenge the deed.
That is true. I am accepting it. But 1960 deed is being challenged in the year 19.
It is not being challenged. It
93.
is only the interpretation of the deed.
Therefore,
If 1960 deed has the effect of transferring right, title, interest and possession, maybe possession, not possession, that will not be. If it transfers title, then the 87 deed would be valid. And if it does not transfer title, then 87 deed would be invalid. And although no specific relief was framed with respect to 60 deed, but issue was framed with regard to interpretation of 1960 deed.
that is.
Parties joined issue in connection with 1960 deed. That was one of the
Yes.
issue before the learned trial. Now, what did the trial court do to it?
Yes.
That is important. That is issue number
That.
7. We are only concerned with that.
Yes.
Issue number 7. Can you read whether the sale deed
Whether the sale deed dated 24/2/1960 executed by Madhumati Devi for self and as a guardian of her minor sons and daughters, along with adult son Shiv Narayan Das, Madhav Narayan Das, and Bani Das, is valid, legal, genuine document executed on permission and sanctioned to liquidate the decretal amount passed by the Honorable High Court.
I may be allowed to pause for a moment. This Bani Das, named in this issue, had died in the year 2010 during pendency of the suit itself. Thereafter, she was never added as party, neither in appeal nor in second appeal. Though the claim was joint, not severable.
Bani Das died on?
Bani Das died on 6/4/2010. That is during title suit, pendency of title suit.
But not substitute.
But now not substituted and not made part, not added as party in title appeal or second
Not party in title appeal.
appeal.
And hence not before this court also. She was not deleted by any order.
No, not by India.
From where do we get that she died on 6/4/1910? 2010?
There is the execution case, objection was filed.
No, execution case. We have to know whether in the suit it was brought on record or not.
I mean, it is not there in the judgment of any judge, either of the judge.
Then we do not. Then we cannot say anything. If it is not there on record, execution में क्या हो रहा है उससे हमको कोई मतलब नहीं। यहाँ के रिकॉर्ड में है तो बात दूसरी।
ट्रायल कोर्ट के रिकॉर्ड में तो आया
आप
नहीं।
मेन मुद्दा से क्यों इधर उधर भटक रहे हैं?
हम नहीं
फायदा
भटक रहे,
नहीं है।
नहीं
बस
भटक।
सीधा सीधी बात है
हम
वो
तो
सेल
केवल
डेट है
फैक्ट
कि
बता
नहीं
रहे
है।
हैं। हम तो केवल फैक्ट।
और यहाँ पे देखिए क्या ये बनाए हैं for self and the guardian of her minor sons and daughter, or along with Shiv Narayan is also the executor.
But he had also died. Shivaran had also died.
And Madhu Narayan,
These are adult children.
They are adult children.
they are adult children. They joined her in the execution of the deed.
No. At that point of time, they were minor.
At that point of time, they were minors.
Madhumalti Devi was guardian.
Was the guardian of all the children.
All the children appointed by the district.
who are not scooters.
Sorry?
There were some other adult members also. They were not scooters. That has come in the
They were not?
They were not in this at the time of that deed.
1960 deed.
There were
Who
some-
are the persons who were to join and they did not join?
Yes, that has come in the the judgment. But let my single.
I think it has come in the judgment. In the appellate judgment, it has come. But we are giving finding para 11 on issue number 7 and 8 and 10.
बताइए जरा।
Running page 56, internal page 9.
पढ़िए इसका फाइंडिंग पढ़िए।
All these three issues are interconnected and interrelated. Therefore, first for sake of convenience, taken first for the sake of convenience, the present suit has been brought by Ujjal Das, son of Madhar Narayan Das. The suit land was recorded in the name of Lucky Narayan Das, great grandfather of the plaintiff. Lucky Narayan Das had a son Satnarayan Das, grandfather of the plaintiff. The suit land came in possession of Satnarayan Das after the death of Lucky Narayan Das. Satnarayan Das had four sons, Shiv Narayan Das, Madhav Narayan Das, Janga Narayan Das, and Sri Narayan Das, and two daughters, namely Bani Das and Ambika Das. It is admitted by both the parties that the suit land was recorded in the name of Lucky Narayan Das. Plaintiffs have filed Exhibit 5A and 5B, which are certified copy of abstract Khatyan in the name of Lucky Narayan Das to show that the suit land was recorded in the name of Lucky Narayan Das. Defendants have also filed Exhibit F to F by 2 which supports this fact. It is the case of plaintiff that Satyanarayan Das, grandfather of the plaintiff, had succeeded to the suit properties on death of his father, late Lucky Narayan Das, in the year 1944 and came in possession thereof. This fact has not been denied by the defendants, rather it has been admitted. It is further case of plaintiff that grandfather and his sons, including the father of the plaintiff, possessed the suit land and the plaintiff possessed the same peacefully till now. But this fact has been denied by the contesting defendant number 1. For the sake of convenience, we will refer the defendant number 1 as contesting defendant, as he is the only defendant who is contesting the suit and other defendants are supporting the plaintiff, and the plaintiff has also sought relief in the present suit in death hearing. It is further case of the plaintiff that one late Nagesh Chandra Das of Calcutta had some business terms with Satnarayan Das, father of the plaintiff. To avoid tax liabilities, Satnarayan Das was prevailed upon by late Nagesh Chandra Das of Calcutta to execute a fictitious deed with incorrect plot number at Malda with respect to suit property. The properties being situated at Rajmahal in Bihar cannot be registered at Malda, and for that fictitious property of Malda, which never existed, were also included in the said sale deed. Regardless of fictitious deed, the suit property remained in possession of the plaintiff's father, grandfather, as usual. Nagesh Chandra Agarwal, alias Das, so long as he was alive, never claimed the suit property, and possession always remained with the father and uncle of the plaintiff. It is further case of the plaintiff that Jagdish Narayan has some business jointly with grandfather Satyanarayan Das of the plaintiff, and he played a trick with Hari Shankar and got a sale deed number 6147 of 1987 executed for the suit property, knowing full well that Hari Shankar and his brother Gauri Shankar had no title and possession over the suit property, and he wanted to dispossess the plaintiff and others from the suit property. It is further case of the plaintiff that in the year 1979, settlement operation was announced in the subdivision of Rajmahal, where the suit properties Hari Shankar and Prem Shankar claimed the suit property before the settlement officer, but the settlement officer, having found the possession of plaintiff, his father and uncle, decided the title in their favor, which is conducted through of title, right title and possession of the plaintiff and others. The record of settlement officer was managed to be removed from the office of the settlement officer and is still untraced. It has further been averred by the plaintiff that although there was no bona fide dispute of possession, but a proceeding under section 145 CRPC was drawn up before SDO Sahibganj for the suit property, and unfortunately, the learned magistrate declared possession of Harishankar and others. It is further case of the plaintiff that defendant first party filed a petition for mutation of his name with respect to the suit property before circle officer Rajman, who was gained over by the defendant, and mutation order was obtained by the defendant in his favor. An appeal was filed by the plaintiff's father and others before the SDO Rajman against the order of CO, which was pending, but unable to get the mutation appeal decided. Therefore, to avoid further delay and harassment, filed this present suit for declaration of right title and possession over the suit land. The case of contesting defendant as regards to these issues is that Satyanarayan Das and his sons were legal heirs and representatives of the estate of Lakshmi Narayan Das, but it has been denied by the contesting defendant that there was any business transaction between Nagesh Chandra Agarwal of Calcutta and Satyanarayan Das. Rather, Satyanarayan Das, grandfather of the plaintiffs, was a debtor of late Nagesh Chandra Agarwal. As the debt was not satisfied, since Nagesh Chandra Agarwal got a money decree from original side of Calcutta High Court as per suit number 1361 of 1935 for rupees 26,700 against Satyanarayan Das. After the decree of Honorable High Court of Calcutta, Nagesh Chandra Agarwal was pressing hard to satisfy the decreed amount. Unfortunately, Satyanarayan Das died on 13th June 1957. So his widow Srimati Madhumalti Dasi, as mother and natural guardian of her minor sons Ganganarayan Das, Srinarayan Das, and for Ambika Das' daughter, applied for sanction to transfer the properties belonging to the family in favor of Nagesh Chandra Agarwal before the district judge Malda, being case number 107 of 59 under Hindu Minority Guardianship Act 1956. The district judge Malda accorded permission by his order dated 21/9/59 to Madhumalti Dasi to execute the sale deed charged under the decree to the decree holder Nagesh Chandra Agarwal, being bona fide to the interest of the minors. Madhumalti Das, after death of her husband, requested the decree holder to liquidate and adjust the decretal amount on consideration of rupees 7,000 and executed a transfer deed in favor of Nagesh Chandra Agarwal through registered sale deed dated 24/2/1960. Nagesh Chandra Agarwal came in physical possession of the property. After his death, his legal heirs and representatives came into possession of the property. After the death of Nagesh Chandra Agarwal, his legal heirs and representatives transferred entire property under Jamabandi number 62, measuring an area 21 Vega, 1 Katha and 14 doors, to the contesting defendant, who registered sale deed on 12/6/1987, and the defendant came in possession. Defendant also got his name mutated in the revenue records. It is further case of contesting defendant that Jagdish Narayan Das had no business with the grandfather of the plaintiff at any time. There is no dispute that the suit land was recorded in the name of Lakshmi Narayan Das. It is also admitted that Satyanarayan Das and his sons succeeded to the suit property on the death of Lakshmi Narayan Agarwal in the year 1944. As we have discussed earlier, Para 5 of the plaintiff has stated that to avoid tax liabilities, grandfather of the plaintiff was prevailed upon by Nagesh Chandra Das of Calcutta to execute a fictitious sale deed at Malda for the lands of Malda as well as Rajmahal. No chit of paper has been filed by the plaintiff to show that to avoid tax liabilities, Nagesh Chandra Das of Calcutta got executed a fictitious deed. Even the plaintiff in his examination in chief has not stated to what type of tax had to be avoided by Nagesh Chandra Das or Satyanarayan Das. If it was the basis, then it was the prime duty of the plaintiff to brought before this court the fact regarding payment of tax. No witness has stated on this fact in their examination in chief or evidence. Defendant Ganganarayan Das, who is own uncle of the plaintiff and has supported the case of plaintiff, was present at the time of execution of sale deed. Although he was a minor at the time of execution of sale deed, has not stated about the tax liability of Satyanarayan Das or Nagesh Chandra Das. There is no basis of this stand taken by the plaintiff. It has further been stated by the plaintiff that Nagesh Chandra Das of Calcutta and Jagdish Narayan Das have some business relation with Satyanarayan Das, grandfather of the plaintiff. But in support of these contentions also, plaintiff has brought nothing on record, oral as well as documentary. Plaintiff, although not directly, but has indirectly admitted that a registered sale deed was executed in favor of Nagesh Chandra Das at Malda, but the plaintiff has not dared to file the certified copy of the above sale deed to brought the real fact before this court. The alleged registered deed has been filed by the defendant, which has been marked as Exhibit B. This sale deed has been executed by Shri Narayan Das, Shri Madhav Narayan Das, Bani Das, Ganga Narayan Das, Shri Narayan Das, and Srimati Ambika Das, who were minor, and on their behalf their mother, Srimati Madhu Malti Dasi, executed the deed. The recital of this sale deed, number 3576, dated 24 to 1960, is very important. It appears from the recital of this deed that a civil case number 1161 of 55 was filed by Nagesh Chandra Agarwal before Honorable Calcutta High Court in original side, and a money decree was passed for a sum of rupees 26,700 against Satyanarayan Das, who was father of the executants of this deed. It has further been written in this deed that after passing of this decree, Satyanarayan Das has died, and if the property charged in the decree auctioned in the execution of the decree, then the maintenance of the executant would be impossible. Therefore, they requested, and on request, Nagesh Chandra Agarwal left the claim except for rupees 7,000, for which the properties of this deed have been transferred in the name of Nagesh Chandra Agarwal. And for the execution of this deed, Madhumalti Das got permission from District Judge Malda for the minor children in case number 107 of 195 under Act 32 of 1956, and the permission was granted by District Judge on 21/9/1959 on behalf of minors. It has further been written in the deed that money decree fully satisfied by adjustment of the consideration amount of rupees 7,000 of this deed. It means this deed was executed in execution of the money decree passed by Honorable Calcutta High Court in favor of Nagesh Chandra Agarwal. Contesting defendant has also filed Exhibit B by 1, which is certified copy of sale deed 7366 dated 26/3/1987. This deed has been executed by Dr. Hari Shankar Agarwal, son of late Nagesh Chandra Agarwal, Srimati Nirmala Gupta, wife of Radharaman Gupta, Vijay Shankar Agarwal, Prem Shankar Agarwal, Shankar Agarwal, and Srimati Jharna Agarwal, Shobha Agarwal, and Miss Krishna Agarwal, and Srimati Durga Rani Agarwal in favor of Pradeep Kumar Agarwal. It is the case of contesting defendant that Nagesh Chandra Agarwal got right title, interest, and possession by virtue of Exhibit B, and after his death, his heir transferred the entire lands of Jamabandi number 63 of Mozar, Raibazar, P.S. Rajmahal to the contesting defendant, and thereafter contesting defendant came in possession and got valid right title and interest. Although it is not the pleading of the plaintiff that Satyanarayan Das had to pay off some loan to Nagesh Chandra Agarwal of Calcutta, which was taken by him during business transaction, and he could not pay to Nagesh Chandra Agarwal. But it has been vehemently argued on behalf of the plaintiff that Nagesh Chandra Agarwal wrote a postcard on 4/6/1954 to Satyanarayan Das mentioning there for execution of deed of land and orchard in favor of Nagesh Chandra Agarwal as security on the condition that orchard will remain under possession of Satyanarayan Das, and after satisfaction of loan by way of installments of rupees 20,000, which was to be deposited at Malda, and thereafter Satyanarayan Das did not follow the direction, and Nagesh Chandra Agarwal brought a money suit against Satyanarayan Das at Calcutta by suit number so and obtained a decree of rupees 26,700 against Satyanarayan Agarwal, who died in the year 1957, and so on the dues as liability fell on the shoulders of legal heir, who requested to Nagesh Chandra Agarwal to minimize the amount, and on compassionate ground, Nagesh Chandra Agarwal fixed the liability upon them to pay off only rupees 7,000 as debt, but as the legal heirs of Satyanarayan Agarwal were unable to pay the cash amount at that time, they, including minor being the legal heirs, with the permission of District Judge Malda, executed Harnanama Kewala in favor of Nagesh Chandra.
So ultimately, this deed was held to be valid, and therefore the subsequent 87 deed was also held to be valid by the trial.
Therefore, it has been granted.
What happened in the appellate court?
Yes. Now, the part was decreed. The trial court decreed part land, not the whole.
Why part?
Yes.
Which part was not decreed?
Yes. That has been dealt with in para 32, issue number 1, 11 and 12, at page, running page 73,
Yes.
internal 23.
Para 32. Going through the case record and on basis of discussion of entire gamut of evidences on record, I find and hold that plaintiff has succeeded to prove his right, title and possession over plot number 60, 61 and 65 of Mauza Rai Bazaar, measuring area 1 Mega 12 rooms. But the plaintiff has failed to prove his title, right, title and possession over plot number 59, 63, 63 by 268 of Mauza Rai Bazaar, area 21, Riga, 1 Katta, 14 rooms.
So this particular property, which was in connection with which the plaintiff proved his title, was not the subject matter of 1960 deed. Therefore, whatever was subject matter of 1960 deed was saved, and the remaining, the right was declared.
Now let
We are only concerned with 1960 deed.
1960 deed,
What happened before the appellate court?
let appellate judgment by kindly received. May kindly let kindly come to internal page 8, running page 30, para 6.
Yes, the following points for
Here
determination.
following.
Okay, which point would be relevant?
Point number 2 will be relevant. Whether the court at Malda had jurisdiction to accord permission to the grandmother of the plaintiff to execute sale deed in favor of Nagesh Chandra Agarwal in 1960, whether the sale deed executed by grandmother was as per law, whether she had no right to do so as per law which existed for the rights of female India in 1957.
So there is no pleading.
When was there is no pleading to this effect that the permission itself was bad in law? There is no pleading?
No pleading. There is no 57.
There is no reading, pleading is required to be
No,
on the
no.
part of the plaintiff.
Pleading is required because once you challenge it, people.
No, we have not challenged. What
Yeah.
we have simply said, Manoj, that we are having title over it. I will ask.
It's one thing to have title over the property, but here a specific point has been raised as to whether the court at Malda had the jurisdiction to accord permission.
Question, these questions has cropped up, Manoj, as per the hearing. So,
That's
Manoj,
right.
this is a question of law. It can be always
Not
decided.
necessarily.
It can be always decided
Now,
at any stage.
No.
उसका सेकंड पेज देखा जाएगा
हाँ.
ऑल टुगेदर नाइन
ठीक
पॉइंट्स
है।
हैव बीन फॉर
ये रोमन 2 कहाँ डिसाइड किए हैं? ये पढ़िए
Number 2 at page 11.
देखिए सर, पढ़िए जरा इसको।
Property for which the permission was being sought is in jurisdiction of Rajmahal. The plaintiffs have asserted that they have no land at any point of time in West Bengal, that too in Malda district in the year 1955. There was a court of district judge existing in Santhal Pargana in district Dumka. District judge Dumka came in camp court to Sahibganj. This practice continued till Santhal Pargana was divided into Dumka, Jamtara, Sahibganj, Pakur and Goda. What was the reason that the grandmother of the plaintiff had to file an application before District Judge Malda under the Hindu Minority and Guardianship Act? The jurisdiction of District Judge Malda was questionable as the property was lying in the subdivision of Rajmahal, so application was filed before District Judge Malda. The relations of Satyanarayan Das would have been residing at Rajmahal subdivision only. The permission to execute sale deed was filed by the grandmother when she had major sons available.
This is not correct. None of them was major. Anyone was major. Anyone was major and on the time, on the date of permission, who was major? And was that your case that somebody was major?
No, my case, Your Lordship, is very serious. We went to the court learned court, that we please declare our title and my possession, and if we found this possession, then my lord recover it. That was by our case. Now, my lord, they have denied all these things. These facts have been brought by them.
No,
They-
your suit was filed for in connection with 1987 saying.
That we have not specifically challenged. Your lordship may kindly see
No,
my
no.
my plain.
You see the and declaration that the defendant first party has acquired no title by virtue of sale deed dated
Yes,
or
but
sale deed of the
there is nothing in the relief portion.
We do not know. This is the suit filed for.
Suit filed for declaration of title.
No. You read the first paragraph of the trial court judgment.
Let
You read the first paragraph of trial court
I will
judgment.
show it.
It is mentioned in the decree also, trial court decree. Amendment हुआ होगा कभी कभी. It's mentioned in the trial court decree also.
Was
There is no
87 deed was subject matter of consideration, and it had 1960 was the back-to-back deed.
But some small amendments have been done in relief portion.
We are not bothered about it. भाई आप डिग्री में कोई error हम थोड़ी समझेंगे. And the degree is in front of me.
Yes.
And there is no such substantial question of law that there is some error in the degree. So we will not take this. Now, Pandora box मत खोलिए. आपका पैरा 1 of the trial court judgment में ये लिखा हुआ है 1987 का
and
सेट.
I-
ऐसे नहीं हो सकता. Was this anybody's case that any of the children were major at any point of time?
It has come in the judgment. I am pointing it out.
No, at whose instance? On the
case
basis of some pleading or without any pleading?
My lord may kindly appreciate. So far as the pleading aspect is concerned, they have brought these facts to the my lord, to the knowledge of the court. So far as we
This
are
deed of 1987 did not disclose these facts.
concerned, did
Yes.
not.
Yes, when
How
it
can
is
it be
no.
possible? कहाँ है बताइए exhibit बताइए.
B by one.
That has not been discussed also.
May not have been, but this fact must have come. Back to back deed का पूरा कहानी रहता है.
बता It has come in para page internal page 19. Major sons were not party to the other. They were redder. They could have agreed with the said knowledge of the appellate court.
Who is the major son? Who were not part? पढ़िए तो जरा ये जो पॉइंट ऑफ डिटर्मिनेशन डिसाइड किए हैं कंटिन्यू करिए इसको
Yes.
पूरा पढ़ जाएंगे.
Yes.
Point 2 also.
यस. पैरा नंबर 8 जहाँ तक पढ़े थे द परमिशन टू एग्जीक्यूट. पहले तो ये जुरिसडिक्शन बोले कि वहाँ पे नहीं हो सकता.
Malta jurisdiction.
तो पहले देखना पड़ेगा हिंदू सक्सेशन एक्ट में
At
कहाँ
that
पर
point of time, Millard, there was jurisdiction. Metropolitan city में कहीं का भी land register, it was amended in the year 2000 or 2001.
रजिस्ट्री कहाँ हुआ था.
रजिस्ट्री हुआ था मालदा ही.
Malda. Malda is not metropolitan city.
मालदा कलकत्ता से लगे हो तो कलकत्ता ही पार्ट का
ऐसा तो double से. Kolkata is a very old court
ओल्ड
and old district.
सब जगह
वो metropolitan तो वही का होगा.
रजिस्ट्रार सब डिफर होता है ना. अभी यहाँ पे 3 सब रजिस्ट्रार है. डोरंडा में एक रांची कोर्ट में एक और कहीं है. 3 सब रजिस्ट्रार है. तीनों जगह रजिस्ट्री होता है. एक डोरंडा में
डिस्ट्रिक्ट जज मालदा की बात कर रहे हैं ना
हाँ
सर?
मालदा की बात कर रहे हैं.
डिस्ट्रिक्ट का जज है मालदा जहाँ से परमिशन मिला
But
है. तो
without-
मालदा was a district at that
It
point
is
of
not the-
time.
it is not
Certainly
the-
different from Kolkata.
It is not the case
इतना
of the
ज्योग्राफी का हम
plaintiff.
लोग को पता है.
It is not the case of the plaintiff that they had no jurisdiction. ऐसा कहीं नहीं केस है. Any minute it is hit by Article 59 of Limitation Act.
अच्छा आगे पढ़िए ना इसको. परमिशन ये तो हो गया
ठीक है,
jurisdiction.
पढ़.
इसका परमिशन बताइए.
The permission to execute sale deed was filed by the grandmother when she had major sons available on that day. The right of grandmother to execute the sale deed is questionable, as the history of right to property in the year 1929-30 till 1956, the female had very limited right to ancestral properties as legal heirs. The application before the Court of District Judge Malda, to my mind, has been filed at the instance of Nagesh Chandra Agarwal by involving property of Malda district. Mauza Panchim Narayanpur Khata number so and so was involved. The respondent has not filed any document regarding the land in Paschim Narayanpur that belonged to the ancestors of the plaintiff, namely Lakshmi Narayan Das, Satnarayan Das, at any point of time in Malda. Grandmother right to execute sale deed was highly questionable, as in the year 1957, the right of females were limited as legal heirs. The appellant claimed that the permission petition made by the grandmother as guardian could not be held in the eyes of law when the evidence of plaintiff is seen no suggestion has been given to him by the respondent that in the year 1957 his grandmother had absolute right to transfer the property in favor of respondent ancestor. The application made before the district judge Malda was without jurisdiction. The appropriate court having jurisdiction would have been the Lex-Loki court, in which the case was district judge Santal Pargana at Dumla or at Camp Court in Sahibganj. The respondent had also not given any suggestion that the grandmother of plaintiff was legally entitled to execute the sale deed in the year 1960. The right of female was very restricted as regards alienation of property. The female could enjoy the property during her lifetime if the same was given in lieu of her maintenance. However, the said land had to be returned back into the joint stock of the family to which it had belonged. The alienation, if not done by the female, was back in stock done by the court wherever the same was challenged. The right of grandmother to execute the said document of 1960 Varnanama deed was highly questionable when she had only limited right to enjoy the property without alienation. The respondent had nowhere stated in his written statement that grandfather of the plaintiff had legal right to execute the sale deed in favor of the respondent's ancestor in the year 1957 under law which existed in the year 1957 and 1960 when the sale deed was executed. The point of determination number 2 is decided in favor of the appellant.
Now, the entire burden has been shifted on the defendant, whereas burden of proof lies on the person who asserts, not on the person who denies. It is their duty to bring on the
Value adoption and maintenance act. Claim decrease. प्लेंटिफ ने तो 1960 का सेल डीड को तो चैलेंज भी नहीं किया है.
That is what
And this
my-
particular deed of 1987 is the fallout of 1960 deed. This
in
suit was
any
filed
case,
when?
in any case,
1993.
either deed of 1987 or deed of 1960, it ought to have been challenged within 3 years. What I did or instrument in Article 59 of the Partition Act.
Who was in possession of the property?
Pardon?
Who was in possession of the property at the time of filing the suit?
Possession में तो अभी लोग
हम लोग हैं, still we are in
The
possession.
possession of the plaintiff over the suit property we confirm. Finding क्या है possession पर? कोई finding है?
We were asking for exclusion, that was the state, the independency of the suit. But the appellate court has thrown entire burden on the defendant. Whereas the plaintiff has come forward to, with some relief. They found in possession of some law. 145 का proceeding.
Issue number 2 है
पढ़िए.
Plaintiff has stated in para 27 of the plaint that cause of action of the suit arose in about a year ago when the order under section 145 CRPC was passed by the executive magistrate with respect to the suit property, and also arose by the order made by CO Rajmahal in favor of the defendant first party. The present suit filed in the year 1993. Plaintiff have not filed the certified copy of order of executive magistrate in respect of the land under section 145 CRPC. The onus was on the plaintiff to prove his cause of action, but as stated, the plaintiff has not filed a copy of order and has ever not been mentioned the date of order. Defendant has filed certified copy of order passed by Shri so and so entitled TR case number so and so. This order shows that the plaintiff Ujjal Das was not party in that case, rather Shiv Narayan Das was the party, and even though Shiv Narayan Das has not preferred suit before civil court. Cause of action is nothing but a bundle of facts. 145 का proceedings वगैरह में हमारा possession था. उसके ऊपर para 29 वर्जन. Nothing more has been brought by the
कल
plaintiff.
कंटिन्यू करेंगे. The question of law is whether the learned court of appeal below has failed to appreciate the sale deed number 3576 dated 24/2/1960 as Brahmanama and cancelled the same after long lapse of limitation. इसको cancel किया है appellate court?
Yes. That then it has been cancelled by the
It is
appellate.
ab initio court.
Sorry?
Ab initio.
Ab initio court.
Tomorrow I will show you.
Has no sanctity.
The deed is either void or ab initio void or whatever. It is limitation in 3 years. I will show you
So
tomorrow.
certain judgments on other ways also. If something is a nullity, there is no question for its cancellation. There are judgments of Honorable Appellate Court 2005, Prem Singh versus Bill. If something is a nullity, then it does not require cancellation.
But once you challenge it, you have to meet the
We are not
limitation.
challenging. We are asking for the title. They are saying that they have got title by virtue of this document. It is their case. It is not our case.
We were defended. When you
Anyway, that is their stand.
when you called us to file written statement and gave him that, he came.
It is not in dispute that the property belongs to my ancestors. What they are claiming that because of certain laws and because of certain money decree, it has been sold for rupees 7,000, and that too at the Malda, where some properties of Malda has also been incorporated just to create jurisdiction. We don't have any property at Malda. And apart from that, the mother had executed the sale deed on behalf of every minor child. It has come in the appellate court judgment. There were some adult persons also who could have.
Who were the adult persons?
It
They
has
have
come
been
in-
examined.
Para 19.
Adult persons have been examined.
No,
From what is the evidence to show that they are the adult person?
it has come in the judgment.
Maybe,
I will show it.
but there has to be some material.
I will show. Question for your my lord consideration that the deed is a varnanama means it is a mortgage or it is a sale. That what is the question of law which has been framed. If once it is a varnanama,
This is not the question.
Merely because it is Bharna-nama, that does not mean it's a
no,
mortgage
it
deed.
will
We
have
have
a
to
very.
see.
it
No,
will
no.
have a
We
very-
will have to
Recital.
decide. We have to see the recital.
Yes, it has to be seen. The recital
Yes.
has to be seen.
We have read the
But
full text of
if
recital.
if the deed says so, if the deed says so, then its nature is something somewhat suppose a mortgage. Then it's once mortgage is always a mortgage. It is also a principal. 3 years limitation will not come into it. So
Mortgage
what
for
is-
what?
Mortgage of the mortgage is the nature of mortgage.
Mortgage for what value?
7,000. That what is written? What is
Mortgage for 7,000.
7,000. If suppose the
Did you enforce the mortgage?
No, if it is.
Did you enforce the mortgage deed?
No, what I am saying.
Did you enforce the mortgage
No,
deed?
what I am saying that if it is a out and out sale deed, then the matter it can be otherwise. But if it is a mortgage, as the very word is Bharnanama.
That's right. So,
Bharnanama means
yes, let us assume that it's a mortgage. So,
if it is assumed it is a mortgage, then the limitation of 3 years will not come.
no. If it is a mortgage,
My lord.
then how can you claim that property without enforcing the mortgage?
That what I am saying.
First, you have to enforce the mortgage.
That what I am saying. So then, my lord, if somebody in some later points of time, if suppose a suit is brought, my lord, then the question of
See, if
limitation
it
will
is
not
a
come.
mortgage, you have to enforce the mortgage.
I will show some judgment. There are judgments to that effect. That once mortgage is always a mortgage.
That's right, it will remain a mortgage. But did you enforce the mortgage?
Question of what my learned senior counsel is raising, my lord, the limitation
You are not,
issue
you
is
can't
3
avoid
years.
my question like this.
3
I
years.
want to know if it is a mortgage deed,
My lord.
one has to enforce the mortgage deed
Okay.
in order to claim a title over it.
They have also not find any
You
formula.
forget it. When you say that it's a mortgage deed, one has to enforce the mortgage deed.
Not a
Merely
legal-
without enforcing the mortgage deed, the person cannot claim title over the property.
My lord, so far as the title is concerned, my lord, mortgagee will never have a title. That what is the law?
That's right.
My lord, may kindly
You
consider.
are the plaintiff, no?
I am the plaintiff.
You are
so
the
my
plaintiff.
title will never go. It
That's
will
right,
never
your
go. It
title will never go.
Never go. So
But-
far as his title is concerned, my lord.
But you will gain the property only when you enforce the mortgage
I
deed.
have filed a suit for that.
You have
To
not
declare
filed
my
a suit
title.
for enforcement of mortgage deed.
For recovery of possession for parent.
No, but recovery of possession does not mean that.
I-
Because in order to enforce the mortgage deed, there has to be a mortgage money. You have to invoke the
My
mortgage.
lord, that
You have to enforce the mortgage
Your
through a
Lordship,
court of
Your
law.
Lordship may kindly consider that, my lord, so far as the nature of relief in this case, Your Lordship, it is regarding
It is
tax.
something like एक बार tenant को दे दिया तो उसको defaulter घोषित करके ही recovery हो सकता है. If you say it's a mortgage deed, then you have to enforce it.
लेकिन फिर दोबारा जो 1987 में टाइटल लगा इनको नहीं होगा इनको तो ऐसे कभी नहीं होगा कभी नहीं होगा इनको टाइटल इनको कहाँ से इनको पावर आ गया बेचने का?
Enforcement of mortgage deed का जरा limitation
अब
देख
देख
लीजिए.
उसमें कोई लिमिटेशन नहीं है लिमिटेशन
ऐसा
नहीं
नहीं.
हम हजूर को हम दिखाएंगे
ऐसा नहीं है.
नहीं हम दिखाएंगे there are several judgments on this
Judgment छोड़िए आप सीधे limitation
हम
act पे आएं.
दिखाएंगे limitation इसमें मॉर्गेज के लिए नहीं है
Enforcement of mortgage.
हमको
के
जब
लिए-
नॉलेज होगा तो हम ला रहे हैं अच्छा वो भी सब माइनर है लेडीज हैं these are the circumstances to be considered
Minor है, ladies हैं, ये सब कोई
नहीं
circumstances.
circumstances है और इसको तो करा लिए सच
कल
कुछ
सुनते हैं. Third in part. Post tomorrow.